Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by Justice Wolohojian and Justice Sachs. We will be hearing 3 cases this morning. We are, of course, sitting by video conference rather than in person due to the ongoing pandemic. The rules for oral argument are the same here as they are in the courtroom when we hear arguments live, which is to say 15 minutes per side with no rebuttal. The first case we'll hear this morning is number 19-905, Commonwealth versus Morris. And we will hear first from Mr. Lattimore.
Good morning. May it please the court, Joseph Lattimore on behalf of Michael Morris. Although the Commonwealth makes a strained argument based on the meaning of the word any in the judge's written order, a review of the motion judge's reasoning from the hearing reveals that there was an abuse of discretion here when she denied Mr. Morris an evidentiary hearing on the motion. At page 6 of the transcript of that hearing, the judge asks about the contents of the transcript of a prior proceeding for a probation violation matter that was stemming from this particular case. And then at page 7.
Can I cut to the chase?
Certainly.
We can affirm on any ground apparent on the record. If we remand for an evidentiary hearing, who has an expectation of privacy in that open, locked but glassed-in foyer, such that there's anything to be heard, putting aside what the judge said?
That's a determination that has to be made, Your Honor, after a full evidentiary hearing where the facts are flushed out. We don't know.
But I can see you having to make an offer of proof or something, right? I'm trying to figure out what the purpose of the hearing will be if everyone goes in and they conclude that under DORA, a common area that's locked in an apartment building like that gives rise to no reasonable expectation of privacy in anyone as a matter of law. So what's the point of the hearing? If that's the correct statement of law, which I don't.
We don't know whether this particular issue is governed by DORA and other cases that hold similarly, because we didn't hear precisely the facts that need to be heard in order to apply the law. Okay,
tell me a fact. Tell me a hypothetical fact that changes this, takes this out of DORA. Well, tell me something someone could say at the hearing, and then we're out from under DORA.
That Mr. Morris was an invited guest of someone who resided in that particular building.
But it's
why would that make a difference?
Because that would take it out of the realm of. And I'd like to add to that, I'm sorry. I would add that access to that area was limited to the use of a code, for instance. And therefore,
it's a locked door. Access is clearly restricted. Either you need a key or you need to buzz or something, right? I mean, it's locked. I think we can all agree it's a locked common space of an apartment building.
But I don't think that ends the analysis, because
tell me why not?
Because even a locked area could potentially be readily accessible to the public if there are measures that are taken by those that occupy the property to make it more difficult for members of the public to access that area. Then our argument that there's a reasonable expectation of privacy among those that live there and their guests is stronger.
Who has the burden of proof on the question of whether anyone has a reasonable expectation of privacy in the place?
Well, the defendant has the burden of coming forward with some evidence, and Rule 13 governs what needs to be put in the affidavit.
Right.
I agree with
what was put forward here that would, I'm not saying prove, but at least give rise to the need for an evidentiary hearing in terms of the materials, the affidavit that was put forward to the judge here.
Well, I would concede that the affidavit in this matter was insufficient.
Okay, so if what we're doing is to review the judge's decision in deciding this without an evidentiary hearing, on what basis can we say that the judge was wrong when there's nothing in the affidavit that would put this issue to the judge in a way that would make the judge think that an evidentiary hearing is in order?
Recently, I believe Friday, I submitted a Rule 16L letter to the court, which brought to the attention of the panel the decision in Commonwealth versus Penny, which was decided this year. And in Penny, in footnote 4, the court determined that even though the defendant did not specifically raise an issue in his motion, where the judge embraced the issue and engaged in an analysis of an issue, that legal reasoning from embracing the issue is properly before the court.
Was that a denial?
It's not waived.
Was that a decision to hold or not hold an evidentiary hearing?
That was not a decision, I don't believe, that addressed
right. That was
this specific.
Right. Wasn't it talking about whether or not a particular legal argument had been raised on point, as opposed to here, which is really a factual point. And it is obviously ultimately a legal determination, but there needs to be some factual basis presented to the judge. No?
Right. Well, the reason I brought that decision to the court's attention is that if the Commonwealth were to argue, he waived that issue because he didn't put it into his affidavit in motion to suppress. Penny is saying, no, that's not the case. If a judge goes beyond the affidavit and the motion and starts to look into other facts that aren't included therein, then they embraced the issue and it's properly before this court. And that's exactly what my argument is here.
I don't think that the Commonwealth is really arguing waiver. Well, at least I mean, we'll hear from them, but I didn't really understand that to be the case.
Can I ask a question about the facts here? If no evidentiary hearing was held, how do we even know this is a multi-unit building?
We don't.
Why are we assuming this is a multi-unit building, not a townhouse? In fact, I just looking at the affidavit, how was the judge supposed to know even where this building was? Or, I mean, why do
she asked for a factual recitation from the Commonwealth.
From the Commonwealth.
And the prosecutor gave it to her, and her analysis embraced that factual recitation that was given by
the recitation was from what? From a police report,
police report. And she also inquired about what testimony came out during a probation violation hearing by the very same officer who authored the report.
Was the police report offered in evidence?
It does not appear that it was offered into evidence during the hearing, but The prosecutor read from that to a great degree.
And to
And
what,
our,
how do we, I don't understand that exactly. Is that an offer of proof, or are those
No.
uncontested facts? How is the judge, why should the judge, the lawyer isn't under oath or anything, right?
well, the lawyer's an officer of the court.
Yeah, okay, so they're still not under oath, right?
No, not under oath, but it's
So I
not
don't
a,
understand how this is a basis for deciding anything, actually, now that I think about it.
I agree with you. She should have gone into those facts, but she did. The correct analysis here would have been, I'm going to deny this motion based on the affidavit and the motion itself, because it didn't present a sufficient factual basis. But she asked to hear facts that went far beyond the affidavit and the motion, and her analysis weaves
We have the transcript. I'm looking for the transcript here. Do we have that?
Oh.
It should be there.
But where this was a warrantless search, wouldn't the burden be on the defendant to initially come forward with some showing that a search actually occurred?
Well, certainly, but he didn't have the opportunity to.
But he didn't put that in
establish
his
that
affidavit.
by evidence.
It wasn't argued, that I recall, at the hearing that no, the Commonwealth's recitation of the facts is wrong. There are facts that show that someone had a reasonable expectation of privacy in the in what might be sticking out from under a sweatshirt in a foyer with a glass door that the public could see through. I didn't see that being put forward as an issue, that factual issue that the judge needed to resolve.
Well, counsel for the defendant didn't advance it to the degree that I would have. However, the judge got into an extended colloquy with the parties regarding these facts that went beyond the affidavit and the motion, and she seems, her analysis seems to be dependent on whether or not Mr. Morris has a property interest in this particular area.
Okay, this takes us all back though to, I think, Justice Rubin's initial question. If I hear you correctly, what I think you're saying is, if the judge had just looked at the affidavit and the motion and said, there's nothing here, motion denied without an evidentiary hearing, then I take it you say that would be okay. Because
I'd be hard pressed to argue otherwise.
Right, because there's really nothing in the affidavit. So
that goes to the search of the building. I agree.
right.
With you.
So what difference does it make if we can affirm on any grounds that the judge inquired further to some degree? I guess that's what I'm struggling with. If the judge wouldn't have made an error, if it wouldn't have been an error to deny the motion in the way that it was presented initially, then what difference does it make?
It's an abuse of discretion if you don't understand the law, and it's in the interests of justice for this court to review faulty reasoning by the judge in this case that denied Mr. Morris a significant proceeding in this case. If he prevails on the motion to suppress, the Commonwealth does not have the evidence that it needs to support this conviction, and the conviction will be vacated. So that's my response to that, and the principle that that is addressed in the Penny case, that where courts, where they venture into this territory and begin to analyze things that even weren't raised by the defendant, they're fully reviewable by this court. And so that would be our position.
You have not too much time left, so I'm hoping you can turn to an aspect of the sentence.
Yes.
That's can you deal with the sentence a little bit?
Certainly. Our position is that the judge crafted a sentence that fits within the confines of the law. And I would say that in discussing this issue, it's important to note that before trial, the Commonwealth had agreed to recommend awarding Mr. Morris 431 days of credit towards a sentence on the conviction for the unlawful possession of the firearm, even though Mr. Morris was already serving a sentence on the probation violation. And the prosecutor was also agreeable to running the sentences concurrent. But then after the trial is over, suddenly the Commonwealth has a different position on this, and unconvincingly they argue, well, it has nothing to do with the fact that he exercised his right to a jury trial.
I'm sorry, maybe my question was not precise at all. With the Commonwealth's argument of double counting of days, can you tell me, if you're able, why that's not correct?
Yes, I would be happy. I'd be happy to point to two record entries if the court would allow me just to go over.
Answer, yeah.
Thank you. I would point to my record appendix at page 12 and the Commonwealth's record appendix at pages 22 to 27. Simply put, the judge in this matter did not at the same time that the judge on the other matter from the BMC counted when awarding credit. There are two separate periods. The Commonwealth misunderstands what was counted towards the sentences.
Okay.
And I've laid that out in my supplemental brief, or my reply brief rather. Thank you for your time.
If there are no further questions, Judge, are you set on that? Okay, your time has expired. Thank you for a very good argument.
Thank you.
We hear now from Attorney Knight.
Good morning, Your Honors. ADJEI Aaron Knight on behalf of the Commonwealth, asking this court to affirm the defendant's conviction. I'll start with the motion to suppress. I believe that Your Honors are correct that the affidavit in the motion gave the judge nothing to go on here. There was nothing to suppress. And I think that that's where we start. Under Rule 13, there was just simply nothing that the judge had before her to suppress. The motion and affidavit make absolutely no mention of the apartment, the sweatshirt, the gun. They make mention only of the stop of the defendant, which resulted in nothing from his person and no statements to be suppressed.
But there were facts read into the record, and I've just looked, and at the outset, it appears the parties say they don't disagree about the facts, and then the judge asks the prosecutor, I don't know if it was you or somebody else, to recite facts. The only fact we know about this building is that it's an apartment building. If I thought that DORA did not apply to a 2-unit apartment building, or maybe even a 3-unit apartment building, we don't know whether this is a 2 or 3-unit apartment building, do we? And wouldn't we have to demand for a factual finding about that?
I don't think that respectfully, Your Honor, I don't think that matters. I think DORA's holding is generally the fact that where it's an area routinely used by others, and there it was the apartment building, and I think here it is that entryway, which if you think about it commonsensically in the Boston area, a lot of apartment buildings have a general vestibule to enter that is really just for residents. And I think that's exactly what DORA and if you look back at my brief, Montanez say is there is no reasonable expectation of privacy for anyone in these common areas. And I don't think that that's
if I thought though, you're just quarreling with my premise. If I thought that, I don't think the police can go into locked areas of buildings without warrants or any suspicion. At least when there's only 2 residents of the building, admittedly in 2 separate apartments. If I don't think that the fact that a second person walks through the area routinely is adequate to destroy the first person's expectation of privacy, do we need to remand?
I don't think so, because that's just simply not the law, Your Honor, respectfully. I think
No, I
that,
understand that you're, that's, I don't believe there's a case in Massachusetts on a small apartment building. And I note that I believe Dora itself talked about the division among courts of appeals around the country about this. Dora says what it says and applies how it applies, but to me, whether someone's expectation of privacy is reasonable or not may have to do with the difference between someplace being Grand Central Station and someplace being the, front foyer of their house that has 2 doors off of it.
and I would agree with Your Honor in that. And I think that that may be a factual basis for determination. But I also think that under Your Honor's premise here, under your hypothetical here, in this given situation, the officer looking through that glass door also saw the butt of a firearm, which, again, anything on the record, this court can affirm. You would get a warrant exception to a warrantless search at that point, but we don't.
Slow down. What is the exception that allows him to go through a locked door to an area to which he does not have lawful access? Doesn't he need to freeze the area and go and get a warrant? I don't understand.
Not necessarily if it's a public access area where a firearm is found.
The door was locked. The door was locked.
I understand that, Your Honor, but it was a public access area. And I think given the facts that were read into the record, which I would point out is very typical in a district court or a district court motion hearing, even if it isn't an evidentiary hearing, for the judge to get a sense of the facts of the case. Because if she is going to make a decision, even on the papers, it's still important for her to understand. And there was, as you said, there was no objection to the facts as they were read in. I would also point out,
shouldn't they actually be put on the record under oath so that they're evidence?
Your Honor, the prosecutor is an officer of the court and has a duty of candor to the court.
Yeah, of course, everyone has a duty of candor. Was the officer cross-examined?
No, Your Honor,
the lawyer? No.
So that's, hold on. It doesn't seem to me to matter, because we can all agree this was not an evidentiary hearing, so people aren't put under oath. So it just doesn't matter. Lawyers make representations all the time in non-evidentiary hearings. It seems to me that the question is whether by opening the door to considering factual matters outside what the defendant presented in his affidavit and his motion, somehow those additional matters placed a duty on the judge to conduct an evidentiary hearing.
And my answer to that, Your Honor, is I think here what happened was the judge was giving the defendant a bit of leeway where the motion really didn't raise anything to suppress. And I don't think that she should be, I don't think her discretion was abused by trying to give the defendant a little bit more leeway into figuring out what it was he was trying to claim, where he filed a motion to suppress with no evidence to suppress. So I think given that situation,
why isn't the gun the evidence they want suppressed?
Because if you read the defendant's motion and his affidavit, he makes no mention of the gun, the apartment. He makes mention that he was charged with a gun, but he doesn't make any mention of where that gun came from, how that gun was discovered. It was not a result of the stop. The stop happened after the gun was discovered. So I would just again rest on the fact that under Rule 13, there was nothing to suppress. The judge gave him a little bit of leeway in trying to figure out what the claim is he was actually making. And because of that leeway, it can't be said that she abused her discretion in still denying his motion.
Can I ask you about your cross appeal for a second on the number of days?
Of course.
How do we know that the credit in the at least 52 days of the credit given in the probation revocation proceeding was not for the time that the defendant was held on the underlying charge prior to being placed on probation?
Sure, Your Honor. So I just want to represent that I'm an appellate lawyer for a reason. I'm not a mathematician, but my calculations from the docket, if you look at the Commonwealth's appendix, page 17, I believe, it gives the time that the judge in this instant case gave for credit as from 9/22/16 to 12/22/16 being 92 days, and then 2/16/17 to 3/27/17 being 40 days, resulting in 132 days. Our argument is that he is not entitled to the 56 days which overlapped. And if you look at the defendant's appendix, page 14, the Commonwealth's appendix page 15, it talks about, I'm sorry, the defendant's appendix, page 14, it talks about the number, that number being, again, and I, with calculations here, I believe it would be from February 16th, 2017 to March 28th, 2017, which is the day he was surrendered, being 40 days. And then to that, you add the time he spent in custody awaiting that scheduled surrender.
I read your brief to hypothesize that there was overlap.
Sure.
If you see that you put in the sentencing hearing from the probation violation, where we can understand which days he was and wasn't given credit for, because your brother has pointed in his brief to a period of 52 days that is not within your calculation that I gather would have been dead time had it not been applied. And he says maybe the probation hearing credit was for that. Now it's not 57 days, it's 52. I don't know what the other 5 are, but all I'm saying is you're the appellant, and I feel like I'm left speculating whether there's overlap between these days for which he's given credit or not. And I don't know how I can say you're right and it's overlapping days if I don't have the sentencing hearing or something from the probation.
Sure. If you go to the central docket, which is in the Commonwealth appendix at page, I would point to page 27. And I hope that the numbers are still the same. I have mine in digital form. It does say there's a credit of 56 days. And if you do the math as to what I just mentioned, those dates that I mentioned in my brief, that does add up to 56 days. Now, we do not have
the 52 days. I mean, there could have been a miscalculation, right? 52 is close to 56. I mean, you've hypothesized, I think, but maybe you're answering my question. That is, maybe you're saying you think it's the 56 days are these ones. And that's all you got, that's your guess.
I think it's more than a guess, Your Honor, but in any event, I think that
okay, why is it more than a guess? You don't know.
Because you can do up those days to add up to the exact number, and given the timeline of that probation revocation proceeding, those dates would line up. And I think that the court can consider that. And I also think that the jail credits aside, I think what's really important here is the nunc-pro-tunc, and nunc-pro-tunc being maybe a red herring in the words of nunc-pro-tunc, but this was a mandatory minimum sentence that cannot be nunc-pro-tunc to run back before it was imposed. A mandatory minimum sentence needs to—
Well, I would have thought every sentence couldn't be nunc-pro-tunc'd back to before it was imposed, because that allows the judge to shorten the sentence. I'm shocked by it, but then I see these 2 cases, one from us and one from the SJC. It might be dictum, but it says pretty clearly you can get them to run unrelated charges and you can nunc-pro-tunc it so they're running concurrently. Now, I don't know why that would be the rule, but I think we're bound by that probably.
If I may, Your Honor, and please bear with me because there's layers here. I think the Barton case is a jail credits case. And this case, this instant case, the judge had expressed wanting to give the defendant credit for the time that he spent. The Commonwealth showed her precedent that said she could not give jail time in the way that she wanted to due to the overlap of the jail credits. So what she did was she, in effect, to kind of thwart that, nunc-pro-tunc the sentence to that start date of the probation surrender. Now, nunc-pro-tunc, as I'm sure this court has read, is an administrative proposition.
What about Commonwealth versus Leiden?
So Leiden, I believe, is also more towards jail credits, and I understand the defendant—
a jail credits case.
Well, it talks about how
it permitted running
to the commencement of a prior sentence.
Right. It permitted the running of a state prison sentence to be run concurrent with the commencement of a House of Correction sentence, nunc-pro-tunc.
Correct. And what Leiden did was it effectually ended that first sentence to I don't want to say release him, but to start that next sentence. So that's not this situation. And I would also point to the fact that this, again, is a mandatory minimum sentence. And if you look at the statute, 26910A, it literally says that the mandatory minimum 18-month sentence can't be suspended, and it can't be reduced, and it is not eligible for probation, parole, work release, or furlough. So I would just point that mandatory minimums are very different here.
But it doesn't say it can't be run concurrently with other sentences, which I
It
think,
does not,
which other
and that's
statutes
not what
do.
I'm arguing here. I think, say that two sentences were imposed on this case, that mandatory minimum could absolutely run consecutively with this. The problem is starting the mandatory minimum back to that probation surrender date, because that in effect shortens the sentence unlawfully. And I think the crux of the matter is that non-protunct is to go back and fix the record. It's to go back and docket something that should have been docketed that wasn't docketed. Where the cases talk about, especially Barton and Leiden, talk about non-protuncting a sentence back to a certain date, I think it's really a red herring. It's more about giving credit. And here, mandatory minimums talk about they're mandatory minimums for a reason.
Can you remind me why it is that she couldn't have given credit for time served awaiting trial, at least to the extent that he was incarcerated on the probation violation?
Yes, so that's the that's the proposition that he would be double dipping, getting credit for both times, because when he's serving a sentence on that probation violation, he's serving for that probation violation. He's not serving for this case. And under the case,
why can't it be run concurrently?
Because at that point he wasn't serving for this case. He was serving for that case. And so if we were to give him the credit, and I think you can look at Commonwealth versus Harvey for this, if you were to give him that credit, he would effectively be serving less time than the mandatory minimum requires.
What precludes the judge from running this sentence concurrent with another sentence for an unrelated crime?
Your Honor, if I may, I see my time.
Yep.
Yeah, no, you can answer.
I don't think that it does.
Is there any case or statute or something that precludes this mandatory minimum from running concurrent with the sentence for an unrelated crime?
I do not believe so, not to my knowledge.
Okay, so in that sense, I'm not sure that I understand your argument that this, quote, shortens the mandatory minimum. Because if it can run concurrent and the person might be serving a 20-year sentence and on this one get 18 months or whatever it is, mandatory minimum, then you could say, according to your use of language, it would then be shortened, because if it ran concurrent, he wouldn't be serving it. So how is it then that nunc pro tunc does anything different than than running it concurrent? Just happens to run it concurrent back to an earlier date.
Sure. I think it's because, again, with the double dipping of the jail credits and the mandatory nature of this sentence is he is supposed to serve those 18 months. And if you look at the actual statute that talks about the mandatory minimum for this particular charge, it does talk about how he's not allowed to, that sentence cannot be reduced, it cannot be suspended. And I think in light of the nunc-pro-tunc nature, that goes directly against the statute. And I would also just,
I think we understand your argument. Your time has expired. Thank you very much. Excellent arguments from both of you. Interesting and odd questions presented.
You're streaming, Justice Rubin.
We're not recording.
The case is now being recorded.
Good morning, everyone. Welcome back to the Appeals Court. I'm Justice Rubin. I'm joined today by Justices Wolohojian and Sachs. We are hearing this case by video conference rather than in person due to the ongoing pandemic. The rules for argument are the same as they are in our courtroom, which is 15 minutes per side with no rebuttal. The next case we will hear is number 19-1686, Commonwealth versus Fernandez. And we will hear first from Attorney Natola.
Uh,
I think, Your Honor.
Oh, I'm sorry.
Commonwealth appeal.
I'm sorry, you're right. I've
No.
done this backwards. We'll hear first from Attorney Zhang. You can
Morning.
have 7 extra seconds at the end.
Good morning. May it please the court, Kristen Zhang for the Commonwealth. In this case, there's abundant evidence reflected in the judge's findings of probable cause to search the trunk in this case. There were items recovered from the defendant and the vehicle during a proper pat frisk search.
Can we just cut to the chase about the
Absolutely.
items discovered from the vehicle? So I understand that the Detective Delaney and the others were all experts in narcotics interdiction, and they testified about this corner of a baggie that was found in the door compartment without any residue in it. They never testified about how such a bag or corner of a bag could be generated in the ordinary course of a narcotics dealing operation. I understand how a bag with some residue in it, a corner bag with some residue in it, might be indicative of drug dealing, but a clean corner, what does that tell us?
I don't think it's fatal to this case, given the other things that were recovered from the defendant himself, taking all that together. But it does show that there were some instrumentalities to drug distribution found in the car itself. And that's important because it ties the evidence that the police were looking for, that they expected to find in the vehicle itself.
I walk you through this piece because I'm trying to sort it out. First of all, it's my impression, I think it's from Commonwealth versus Garden, that you could have probable cause to search the passenger compartment without probable cause to search the trunk. Do you agree with that?
Yes.
So we need to find probable cause that there is something, evidence or instrumentality of crime or contraband, in the trunk.
Yes.
And the link to the car here is there's a drug dealer in the passenger seat.
Yes.
I don't know what the Commonwealth's position is, but I'm guessing you can't win just on that. Otherwise, you could search every trunk when you arrest a drug dealer in the car, which is to say a lot. And I don't see case law that says that. So there has to be more. And
Sure.
okay, and I'm willing to say there's at least probable cause to believe the guy's a drug dealer. Okay, fine.
Mhm.
There's a corner cut of a baggie, which you've described as an instrumentality of drug dealing, and I agree with that. I mean, I don't have any corner cut baggies around. I've never seen a corner cut baggie, but I've read an awful lot about corner cut baggies. And okay, now the rest of the bag isn't in the car. I don't know if that matters. I don't think there's any scissors in the car. I don't think that matters. But there's a drug dealer, and sitting next to him is a corner cut of a baggie with no residue on it. So it either has been discarded or it hasn't been used yet for anything. How does that get me to probable cause that in the trunk there's something?
Well, I think it's also important in this case, we not only have evidence that this defendant was known to be a drug dealer in the area, but the items recovered from him. So there's a small digital scale with powder residue still on it. We've got cash that's still separated into separate folds. We've got a small plastic bag still with powder residue on it. So
Well, he's a drug dealer.
Right, but that's important because he could have just finished with a drug sale.
Could have, but
you know,
that's
he was-
quite speculative, isn't it? We need something particularly tying the drug sales to the car.
Or to the trunk. Like, I don't.
Well, to someplace beyond the passenger compartment. The
That's
trunk,
correct.
or it could be the engine compartment or whatever. I'm not understanding how a clean corner of a baggie gets generated in the process of drug dealing. I understand how one that has powder residue on it could get generated, but why would anyone cut a corner of a bag off that doesn't, or twist it off that doesn't have any drugs in it? How does that constitute an instrumentality of drug dealing?
I can't quite make that connection because that wasn't really in the record, but I can say it was in the record that these are often, it's an instrumentality of the drug trade. It's something that drug dealers use to package illegal substances. That is what is clearly in the record. We've also got powder residue still on some of these other instrumentalities on the defendant.
On the defendant's person. But I noticed that in the Alvarado case, which you cite in your brief, the court said, the view of an object which may be used for lawful as well as unlawful purposes, even a container of the type commonly used to store controlled substances, is not sufficient to provide the viewing officer with probable cause to seize that object or arrest the individual possessing that object. So here we have a container, a corner of a bag of the type commonly used to store controlled substances, although there's no evidence that controlled substances were ever in this particular corner. And the Alvarado court says that's not enough to provide probable cause even to seize the object, let alone to go off and search other areas.
Well, I think the important distinction from Alvarado is that in Alvarado, the defendant was just a user. He had some cocaine on him, probably for personal use based on what was discovered. In this case, this person is a known drug distributor and he has instrumentalities on his person and in the vehicle where he was sitting. That ties it to the vehicle and also potentially indicates that he had just finished up with a drug sale. I think that's an important distinguishing factor.
May I ask you a couple questions? Assume there wasn't the cutoff baggy corner, the clean one. Is there probable cause to get you into the trunk?
I think based on the amount of items recovered from the defendant himself and the fact that there were 2 cell phones in the back as well.
In the back where?
There were I'm sorry, maybe not. There was conflicting evidence about the number of cell phones discovered in the back seat, but there were 1 to 2.
I didn't think there was a finding of backseat. Somewhere in the passenger compartment, there was either 1 or 2 cell phones beyond the phone that was found on the defendant himself.
I apologize.
What is the closest case, if we took out the baggy corner, what would be your closest case on the remaining facts that would say that there would probable cause to search the trunk, not just the interior of the car, but the trunk?
I'm just looking through some of my cases here to try to take out that factor. I would say, honestly, the 2 cases I cite in contrast to this one, Pacheco and Garden, because those really focused on the fact that what was recovered was clearly the defendant in those cases was a drug user. And I think what really distinguishes this case is that this defendant was a distributor and he had
but what I hear you saying then, okay, so this is tricky, is that as long as the person is a drug dealer, you can search the trunk of any car he's in.
Well, I think if we just had the fact that he was a known drug dealer in the area and that's all we had, that wouldn't be enough. I agree with that. But we also have...
What do these other little facts add other than to confirm that he's a drug dealer? In other words, don't they need to suggest something about where you might find additional evidence? And that the where is the trunk.
You also have to think about what is the evidence they're looking for. If they think that they might have evidence of a crime here, contraband, where would that may have been found? In this case, I think a trunk is a likely place where that evidence could be found. In the other cases where we're just talking about people who have a little bit of marijuana found on them or cocaine.
Is the hypothesis that he is stopping in between drug deals or something, going back to the trunk, getting some more cocaine or whatever it was he was selling? Is that the hypothesis, or just that what is their I mean, I can get a reasonable suspicion of 1,000 things, but there's probable cause to believe what exactly? And in that hypothesis, the probable one, what is going to be in the trunk when you look there? And why is it in the trunk? We don't usually in the middle of driving around, get out, go to our trunk and get something. We take things places in our trunk. So what's your hypothesis?
The hypothesis is the police had enough facts and circumstances here that they would find additional evidence of criminality in the trunk, given what they... Specific,
I don't understand what that means. You mean there would be the rest of the plastic bags back there. There would be a kilo of cocaine back there. There would be, what is it?
There
Probable
could have
cause.
been, I'm sorry, I didn't mean to interrupt you. There could
No,
have
no,
been, there could have been additional instrumentalities of the crime. I don't know, more scales, more baggies.
Scales? I don't know if you need more than one scale.
But more baggies, more drugs. They could have thought that they would have found more drugs back there. And then given given the amount found in this case, the trunk is the place where you would keep something like that. Not in the passenger compartment.
While you're in the middle of dealing, you're going around. I mean, he's got money in his pocket. He's got some drugs in his pocket and a scale. Now, I don't know enough about how drug deals are done to know when you use the scale. Maybe you use the scale when you're selling it to show the people, look, it's an eighth of an ounce or whatever. And maybe you also, or instead, use it when you're pouring out the drugs to measure them before you put them in a plastic bag. I have no idea. But so he's got this scale with him. He's got money. We can hypothesize it came from drug sales. And he's got drugs, which we can hypothesize he intends to sell. Okay, but maybe I just haven't heard enough about it. Usually we hear that, and the drugs are kept in a stash house somewhere, or frequently with less clever drug dealers, they're in the kitchen of his apartment or whatever, right? I mean, there's all these different ways, but usually we don't think, and the whole operation is being run out of his car, right? Where he's got, there's no scissors, there's no, so I don't really understand what it was.
We don't seem to have evidence that he was using the car as anything other than he was a passenger, and the car was being used to get him from one place to another. I mean, there's no indication I see that he was dealing drugs out of the car, which is the nexus that Garden and the other cases seem to require.
I keep repeating this, but I think the residue is very important here because it shows that something had just occurred.
Well,
We don't know that.
If you had found residue in the car, then maybe you could begin to say maybe he was packaging the drugs in here or something. But I'm just trying to figure out what it is, right? We got to get to probable cause, and I'm trying to figure out probable cause to believe that X would be found in the back, and it's fine to say instrumentalities of crime. Sure, okay, but what do you mean? Like, I'm just having a hard time getting to the
I
trial.
suppose it would be that the defendant, who's a known drug dealer, is a passenger in a car with demonstrating some, moving forward, whatever, before being stopped. And then he's pat frisked, and on him he has the tools that are used to measure out drugs and package them. And that a person doesn't travel with those things unless there's also the packaging material, what's going to be packaged in the car. Now, whether that's enough to get you into the trunk, in other words, I don't travel around with a whisk unless what I plan to whisk is also with me in the car. I don't know.
I bet that's wrong. I bet if I found you traveling with a whisk, you'd be on your way someplace else to cook with your own whisk.
All right, well, I guess that's the best I can see for the Commonwealth's argument, is that if a drug dealer is traveling around with the packaging, the tools for packaging drugs, and they look like they've been freshly used because they have residue on them, then you have probable cause to believe that the materials that that person would be using to package can be found in the trunk.
That's
Would that
correct,
be
Your Honor.
a fair statement? Okay.
Yeah.
Can I ask this? Was there any testimony about what it means to physically have the scale on you when you're a
Yes.
drug dealer?
Yes.
And what was the testimony about that?
I don't have the actual site, but there
okay.
was testimony that from, I believe, Officer Hughes that said that this was the type typically used by drug distributors.
And it had residue on it, but there
Correct.
was no testimony about how long after a scale was used to weigh heroin or cocaine or fentanyl, the residue might remain on there. So there wasn't
Correct.
an evidentiary basis that I saw for concluding that there had been a recent use of the scale as opposed to a use days, weeks, who knows how long before.
That's correct. That's an inference that I made, Your Honor.
All right, your time has expired. Are there
Mr.
further
Chairman,
questions?
I believe, I thought that.
Oh, you get 7 more seconds. You're right. Go ahead.
No, I thought that Justice Sachs had a question.
Oh, I got my question in. Thank you.
Thank you
All
very much.
Thank you very much. And we'll actually hear from Attorney Nuttolo.
May it please the court, good morning to the panel. It's an unusual position for me to be in as the appellee in a case where a defendant's motion to suppress has been allowed. And I've been taking notes during the course of the hearing now, and I don't want to go through a detailed list of what the judge found in her findings of fact, but reviewing that list on page 11 of the Commonwealth's brief, you take all those things together, and certainly the court has the power to put them all in a basket and try to see whether what's in the basket constitutes probable cause. But it seems to me that even all the things that the judge found in the motion hearing, put them all together and they still don't add up to probable cause.
Do you think that the combination of things the defendant had on him, including the digital scale, and whether the drug residue can be fairly read to imply recent use or not, I think the drug residue can be used to fairly imply that this particular digital scale is not used for measuring eggs, but is used to measure drugs. If you take the fact that the defendant is a known drug dealer, he's got a little bit of suspicious movement in the car before the car is stopped, and he's traveling with the tools of the drug trade. Would you agree that they could search the full interior of the car?
I believe I do, Your Honor.
So then the line in your view is that they don't have probable cause to get them into the trunk.
Yes, and
what can you articulate for me why the line stops there?
Well, it's
why whatever inferences one can draw from what he has on him are enough to permit a search of the interior of the car, but not beyond.
Well, there's no evidence to indicate, apart from the officer's knowledge and experience, that drug dealers, in fact, travel with drugs in their vehicles. And I think that just because there are drugs found in the passenger compartment of a vehicle, it doesn't mean, it doesn't raise a reasonable suspicion that there are drugs in the trunk as well.
Well, probable cause is what they needed. You might want to stick.
That's right. That's right, Your Honor. You're very right. And I did that for a reason, because I think they don't even get that far.
Was there any testimony from the police?
Yes.
That you would only have a scale on you if you were in fact packaging the drugs in the car?
Excuse me, my recollection is there was not evidence of that sort. So I suggest that that the fact that there was no proof at all that something, a drug transaction had occurred recently, nothing that indicated the recent use of the scale. Yep, it had drug.
Wait a minute, there is evidence of recent drug transaction. He's got cash in his pocket, still broken up into amounts, each of which might represent a drug sale. I mean, I think there's probable cause to believe that he's been recently selling drugs.
Okay, and
Don't you think so?
I'll grant you that by
Okay.
virtue of the presence of powder on the scale. However, that doesn't tell us where he was selling the drugs from. Was he selling it from the vehicle, or was he selling it at people's houses? Was he
Why
selling?
does that matter? I mean, he could be selling it anywhere. The question is whether the instrumentalities of that or the contraband, there's probable cause to think that that would be in the trunk. I mean, maybe he just drives around and he keeps the supplies, some on him, some in the trunk, but while he delivers drugs lots of different places. The question is, though, what gives us probable cause to think that to search the trunk? No, doesn't really matter where he's selling, does it?
No, I don't think it is, except as it might impact on when it was that the scale was used for a drug transaction or before a drug transaction, in packaging up stuff before you go out onto the street.
If there were evidence that this car was stopping and picking up people on street corners and taking them for brief rides to nowhere, would that, in addition to the factors we have here, establish probable cause?
I do.
Allow search of the trunk.
I think it would, because that's one of the classics, one of the classic factors that the appellate courts always take into account. And of course, that kind of behavior is always, I don't know, verified. That's not the right word, but it's always explained in a negative way by trained police officers. So that's quite a different story. And I think that behavior that is typical of a drug dealer would tip the scale. No pun intended, please.
Digital scales don't have to tip.
So, I mean, I think that's about as much as I've got to say, unless the panel.
No, if there are no further questions, I think we understand your argument. Anything from either judge? No? All right, very good. Thank you very much, both.
Yes, thank you.
Okay,
All right, I will let you know.
thank you.
The case is now live and being recorded.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Wolohojian and Sachs. We are hearing argument by video conference in light of the ongoing pandemic. The rules for argument are the same here as they are in our courtroom, 15 minutes per side with no rebuttal. The next case is number 20-89, AGYEI versus AGYEMANG, and you will tell me that how I've mispronounced those names, but we'll, for now, that'll have to do. And we will hear first from from Attorney Chakwara.
Good morning, Justices. May it please the court, my name is Lillian Chakwara, and I represent Mr. Maxwell ADJEI in this matter. To have the default judgment entered against him vacated and allow him to proceed to trial on the issues related to parenting plan, current child support levels, and amount of child support arrearage that are owed in this matter. The default judgment is the result of the defense counsel refusing to make a reasonable accommodation to Mr. AGYEMANG during the lower court proceedings.
Well, or was it a result of your clients not showing up for the pretrial conference?
Yes, my client did not appear for the pretrial conference.
And I just
However,
wanna
he
make
did.
sure- I want to make sure he
Mhm.
didn't file a motion with the court seeking to continue that conference. Is that correct?
At the time, he did not. He did send a mailing to the court and informed Ms. AGYEMANG's attorney of his request for a continuance. He was pro se at the time and
Wait, I
did not
didn't
understand
see
the
anything-
rules of the court.
Yeah, so I didn't see anything in the record showing that he sent something to the court. Is there something in the record that shows that?
No, Your Honor. Apparently, it never made it into the file because it wasn't a properly filed motion for a continuance.
All right, I also understood that he didn't send anything.
Mhm.
He said he spoke to someone at the court. But maybe I misunderstood the record. Anyway,
Yes, he spoke to. Yes.
I understand, first of all, what is the status right now? Has is the father paying the child support award?
Can you hear
I'm
us?
sorry, Justice. I didn't get your question. I didn't hear you.
Okay, what is the status right now? Is the father paying the child?
Yes, I can.
Sorry?
Father is paying. Sorry, sorry, Justices. At the moment, the father is paying the child support. It is above his income, but he is managing to make those payments to adhere to the court order and not to further add to any arrearage.
What's the status on the arrearage?
The arrearage is $13,000. That's the order of the court at the time of the pretrial, was that the arrearage will be $13,000. And my client has been making payments towards the current child support amount. Again, the current amounts are above his income, and he's making those payments. He will eventually make payments towards the arrearage once that is adjusted to actually reflect his contributions to his child, and he has the funds to make the payment.
You've asked that your arguments are that the judge should have allowed either a Rule 55 or a Rule 60B motion to set aside the default, if I understand your argument correctly. But I didn't see in the...
So in this...
Go ahead.
We're having a little technical difficulty here. Can you hear us?
Yes, I can.
Okay.
I believe that the justice was asking...
No, we
Yes,
can't.
I believe the justice was asking what the basis of the appeal is, and if my client filed the motion to set aside the judgment, if I cut that. Yes.
Well, yes, that's
Can
right.
you hear me?
Yes, and that's the, yes.
Okay.
What's the answer to that question?
I'm sorry for the technical difficulties. It's probably from my end, but thank you for understanding. In this situation, unfortunately, my client did not file the motion. Understandably, that would have been the best next step in this situation. However, there was a strategy decision to file an appeal based on the fact that the court did not properly assess the parties' incomes in making the judgment.
Have you ever seen?
It is understood that the...
No, I'm sorry.
Yes,
Go ahead. I don't want to interrupt you.
Justice?
But would you agree that?
It is understood that the lower court judge has the... I'm sorry, I don't want to interrupt. Any questions?
No, you can answer first, and then we'll have more questions for you.
Okay. It is understood that the lower court judge has the right to make a decision when one party does not appear. However, our position is that because the case did not have some certain amount, the judge didn't make any actual determination as to the party's income in making his decision as far as the arrearage and the child support amount.
Have you ever seen a default judgment before in a child support case where an amount of arrearage is found without any evidence in the record?
Yes, but in this situation, there has been, in the record, there has been opportunities. There has been situations where, especially in this case, where the judge could clearly see that there were actual disputes of fact in this case, because the parties have been going back and forth as far as the discoveries are concerned in this case.
I'm sorry.
However,
in the record before the judge, and I'll ask your sister as well, in the record before the judge, was there sufficient evidence to support a finding of a $13,000 arrearage? I didn't see any evidence. I guess there's a financial statement, but I don't know if it was entered into evidence. There certainly was no, I mean, you can have an in absentia trial, I guess, if someone doesn't show up, but I've never seen a case like this.
Exactly, Justice. There is no, there was no actual finding of facts in this case to determine that arrearage amount. If you look at the court transcripts, you will see that the judge basically stated, asked the Ms. AGYEMANG's attorney if it was okay to just cross out her proposed order and make that exactly the court's order without actually making any fact finding or going through a trial without Mr. ADJEI present to determine exactly if that $13,000 is justified, if there was enough documentation for Ms. AGYEMANG to support her assertion that $13,000 is the actual arrearage in this case.
Was there any evidence? I'm sorry, go ahead, Judge.
Yep. Did the father have proper notice that if he did not show up at this pretrial conference, a default judgment could enter against him?
Uh-oh. You seem to be frozen and we can't hear you anymore. There you are, you're moving again. Did you hear the question?
If father received notice that if he went to the pretrial, if he didn't show up to the pretrial, that a default judgment will be entered against him.
Yes.
Right. He did receive the court notice for the pretrial. Again, he was not represented by counsel. He did have, as you can see from the record, he did have limited.
Doesn't it say only that his petition may be dismissed? I didn't see anything in that notice about the counterclaim being subject to a default judgment.
There isn't. So the notice stated that his claim will be dismissed if he did not appear for the pretrial. However, typically the notice does not state that the counterclaim would move forward without him present, because in these situations, the counterclaim is a separate claim altogether, and notice should have been given for that as well. However, because notice wasn't given, as you rightly point out, my client only, if he did know that there was going to be, that the counterclaim would move forward, he did not have notice of that, but he did have notice through the notice from the court that his claim could be dismissed if he did not show up for his own particular claim, because he is the plaintiff in this particular case.
I have only one other question, which is, what evidence was there in the record that this parenting plan was in the best interests of the child? I think we've lost you again.
I'm sorry, I didn't hear that.
What evidence is there in the record? I don't know if you can hear us now. You're frozen from here, but what evidence is there in the record?
I heard that.
Okay.
I'm not sure if you can actually
We can hear
hear
you.
me.
What, can you hear us?
Go with the question.
The question, can you hear us? I think so.
I heard that.
We can only barely hear you, and it's really cutting in and out.
I'm not sure if you can actually
Want to try
hear
the
me.
question
We
again?
can hear you. The video is no good, but we can hear you. So my question was, what evidence is there in the record
Okay.
that the parenting plan adopted by the court is in the best interests of the child?
There's really, other than the pretrial memorandum filed by counsel, by Ms. Agyeman's counsel during the pretrial, there's no other evidence that was on the record as far as the parenting plan was concerned, and whether that was in the best interest of the child. Again, the court did not make any determinations or any fact finding on this particular issue as well. Like I stated, the court adopted the Ms. Agyeman's proposed judgment and did not make any judgments of its own, and solely based their decision on her pretrial memorandum and the proposed judgment.
So are you asking us to vacate the judgment, or are you asking us to order the trial judge to consider a motion to vacate the judgment if you were to file one on remand?
So yes, we're asking to vacate the judgment and remand it back to the trial court to have an actual trial on this case, because there are certain issues of fact that were not developed in the record. There are issues, like I say, that the child support amount, the income of the parties were nowhere in the records. As far as the order was concerned, child support guidelines were not ran in this case, which is required when a child support order is put in place. And additionally, there was no questions from the trial judge as far as the actual suitability of my client to have contact with his child in this case. So our position is that the case should be remanded. And like I said before, the typical procedure would have been to file a motion. However, at this moment, the motion is not possible. So my client's only recourse is for this court to remand, vacate the judgment and remand the case to actually go to trial with evidence presented for each element of the case.
All right, your time has expired, but we have had such technical difficulties that if there are further questions from the judges, I want to give them a moment to ask them.
Can the judge impose a sanction for your client's failure to appear at the pretrial conference? I'll also note, I don't think he filed the required financial information. He made required financial disclosures. What response could the judge make to those?
I'm sorry, Justice, I did not catch the beginning of your question.
Can the judge impose a sanction? Could the judge have imposed a sanction for your client's failure to appear at the pretrial conference and for his failure to comply with his discovery obligations?
Yes, the judge did have the right to impose sanctions instead of outright dismissing the case. And because also the Ms. AGYEMANG's attorney did inform the court that Ms. ADJEI did tell her that he needed a continuance, and that would have been the best. That situation is to impose sanctions for further for him to present the financial documents and set a further pretrial conference date.
Any other questions? No. Thank you very, very much, Attorney Chakura. I'm sure it's difficult with the technical issues we've been having, but this is a very, very helpful argument for us. And we will hear now from Ms. Remillard.
Morning, Your Honors. May it please the court. My name is Maria Remillard, and I represent the appellee mother, EMERENTIA AGYEMANG. This case arises from a judgment of the probate court after a litigant ignored clear court orders that warned that the failure to attend a scheduled pretrial may result in the issuance of a judgment or the dismissal of a complaint. Despite having notice of the pretrial and written instructions as to the steps necessary to seek a continuance, he chose not to appear. As a result, the court issued a judgment of dismissal for his complaint and rendered judgment on mother's counterclaim. And father's inactions have consequences in this case.
Have you ever seen a default judgment entered before in a child custody or child support case?
I have seen judgments entered in paternity cases.
No, but he's not contesting the paternity piece of this. It's clear that there's authority for that, but there's a lot of case law about default judgments in the probate and family court.
There is a lot of case law in the probate and family court with respect to domestic cases. Yes, Your Honor. And notwithstanding that, with respect to the establishing of his paternity and a financial award under 209C sections 8 and 9.
What about child custody?
Child custody pursuant to 209C absent an order of the court, it rests with the mother, sole legal and physical custody until there's a further court order.
Okay, but this is the final judgment.
I am not aware of any anything with respect to that, Your Honor.
And what evidence was in the record with respect to the best interests of the child?
Well, with respect to the best interest of the child, I believe that the statements of counsel and the offers of proof in the pretrial memorandum indicates and that the father, this child at the time of the filing was 6 years old. The father had very limited contact with the child.
The answer to my question is there's nothing in the record?
I wouldn't say that, Your Honor, because
An offer of proof, a statement of counsel? What is that?
according to prior cases, there's a couple cases that I had cited in my brief that indicated that statements of counsel and statements of counsel that's unopposed, where there's no opposition, it can be considered by the court as evidence.
So you think there was a trial here? This was
No.
evidence, it was an in absentia trial?
I am not.
I mean, I'm
saying-
troubled by it. I guess it's obvious. I'm troubled by the procedure here. I don't blame you or counsel for if you were not counsel.
I was
for your
not
client.
trial counsel.
I'm not saying that, but I don't understand a judge. I mean, I don't understand a judge issuing, I can understand issuing temporary orders for sure. But how do you, without a trial, I mean, and frankly, you said at the outset, maybe you can be more specific about this. I read the notice to say his claim could be dismissed. I didn't read it to say, and a default judgment would be entered against him in any counterclaim. I'm not, obviously he should have shown up, but my concern is what happens now? Right, let's say, and we don't know because there is no evidence of it, but let's say it's really in the child's best interest to be with him. I'm not saying it is, but we don't know. And now this child's placement is based on, he didn't show up, I'll cross out proposed order and write in order, and that's the determination. That's a little scary to me.
Well, Your Honor, in these kinds of cases, while paternity of this child was not contested by either party, as both the complaint and counterclaim clearly acknowledged that there was an agreement with respect to that. I think we need to also look at it a step further, because with these paternity complaints, you know, what you don't want to happen is have a litigant avoid court and therefore avoid these orders.
So shouldn't a trial date be scheduled? And if he doesn't show up for that, I mean, this is a pre-trial conference. There's not even a mechanism, unless I'm missing something, for actually holding the trial. And a judgment enters.
As far as the mechanism for actually holding the trial, under the pretrial notice and order, it indicated that the court could issue or order the trial to go forward on the date of the pretrial if it determined that only the parties were
Sure,
the
but that's not actually what happened, because the judge didn't convert this to a trial, I don't think. Are you saying that the judge did?
I don't think that the judge converted it to a trial. The judge awarded judgment to mother in accordance with her requests or through counsel.
Do you think it was a sanction? Or do you think,
I don't see it as a sanction, and father has some remedies with respect to this. So for example, on the child support piece, if there's a difference in between his income now and what the current order is under the Massachusetts child support guidelines, he could file a complaint for modification.
For a change, but what if there's been no, was there any evidence about his income in the record? Or even in the discovery or whatever?
I was not trial counsel, and so I don't have the discovery. I'm solely looking with respect to the record. And with respect to the record, the father had been paying this voluntary amount of $400 and change. I can't recall the exact number, for several years. And it was, I believe the child was 6, and the issue as far as the arrears were only for the child's first 2 years of life. So that's 4 years of paying that amount. And where there's no financial information, you know, a parent who is the primary custodian of the child shouldn't be deprived of support because the other parent does not provide financial information.
No,
So
of course.
I think
No,
that it's certainly appropriate that the court considered the fact that, or considered the statements that this gentleman had been paying this $400 and change a month in child support for 4 years in adopting that.
What relief would the appellant have if he wanted visitation? He wants to see the child Sunday afternoons every other week. What can he do now if we don't vacate this?
He could file a complaint for modification seeking.
What if there's been no change in circumstances, literally the same circumstance? He didn't show up, but he wants them.
Well, he can still file a complaint. The standard is that there needs to be a material change of circumstances since the time that the judgment entered.
Don't you think the child is entitled to, I know the child isn't represented here, but the child is entitled, if it's in the child's best interest, to have contact with the father, that the child's entitled to some kind of proceeding on that?
Because it's not a care and protection case, the child doesn't have standing with respect to that. But I don't think that the judgment indicates that the father is to have no parenting time. The judgment indicates that his parenting,
Yeah.
the judgment indicates that his parenting time is subject to mother's oversight. And there's certainly nothing that indicates that she has prevented the father from having the child. And in fact, based on the representations, was that time that she had provided for the father to actually build that bond, which he hadn't built because he was not present or not active, just didn't occur.
Do you agree with Attorney Chakwar's, and I'm sorry for mispronouncing that, statement about the current status of payments?
I can't speak to that. It's not in the record. I didn't speak with trial counsel as far as anything that was happening today. I do know, in a further response, I'd have to go outside of the record, but I cannot concede her statement that he is paying more than what his income is.
What is the current award? Is it monthly? How much did the judge put in place?
It's a little bit more than $100 a week. It's 400 and change. I can.
Is that no? Is that it? And is it the amount that he was paying voluntarily, or it's more?
Yes.
Than
It is the same amount that he had been paying voluntarily for 4 straight years.
The section 209C, section 9 says a default judgment may be entered, or a judgment, an order or judgment of support pursuant to this chapter shall be entered, notwithstanding the default of the defendant or his failure to appear personally, upon a showing that notice was served in accordance with the applicable rules of court. Does that have to be notice that a default judgment may enter if the party doesn't appear, or does it just have to be notice of the pendency of the action, such as might have been served at the outset? Well, I guess this was the father's action, so showing of proper service of the counterclaim. Is that sufficient to be notice under 209C9?
My reading of it was that notice of the pending claim, because with due process, you need to have notice and the opportunity to be heard. And notice, as I read it in this statute, I read it as either the service of the summons with the complaint or service of the counterclaim in accordance with the rules of domestic relations procedure.
Do you know of any authority on what notice means in 209C9 or 8, I guess, for that matter?
I don't know specifically that I can cite right now, no. I can follow up and look at it, but that is not something that.
So if notice meant notice that a default judgment will enter if you don't appear at a particular proceeding, then would you acknowledge that he didn't receive that specific notice here?
while I think to say that the notice regarding the dismissal or the judgment on the complaint didn't include a counterclaim, I think that's concerning because it's considered one action, because these counterclaims were compulsory counterclaims because it was directly related to the action. So while that word was not in that notice, I don't think that it's reasonable to say that I don't think that it's necessarily a, sorry, I just lost my train of thought. With respect to the notice for a dismissal of the complaint, the failure to have the word counterclaim in there, I don't see as fatal because while they're two different actions, they were basically brought with a complaint and a compulsory counterclaim. If that answers your question.
Would it be fair to
I'm sorry, go ahead, Judge.
Would it be fair to interpret what notice means in these statutes in light of the policy or the general preference against default judgments in the probate and family court? And I'm referring specifically to the case of Impressia versus Impressia, which I believe was cited in at least one of the briefs. In other words, there's no provision for a default under Rule 55 in the Rules of Domestic Relations procedure. There's a preference for adjudicating things on the merits.
There is a statement in case law indicating that there is a preference that it be adjudicated on the merits and not default. And certainly with respect to Section 8 and 9, and you have the statutory mandate indicating the judgment shall enter either if he fails to respond or fails to appear. So I don't think that case law can override clear statutory direction with respect to that. I see my time is done. If there's no further questions.
Are there further questions though? No, very good. Thank you both very much. Excellent arguments, interesting questions.